First of all, check the disclaimer out at the end of this video. Never ever ever disclose to your current employer the name of the employer that you're going to if you're an employee, at least in the United Kingdom. It can only cause bad things for you as the worker. Under a system of capitalism that we live under, this disastrous, disgusting dog-eat-dog system which is based upon the exploitation of workers as wage slaves, essentially. We permit, under our disgusting system, restrictive covenants in employment contracts. We also permit restrictions in other types of contracts, but we permit non-competes. That means you're not allowed to go to an employer for a new competing employer for a certain length of time, 3, 6 months to a year. We permit non-solicits, where you would not be allowed to deal with customers or suppliers to your previous business. We permit non-poaching covenants that would stop you from saying, hey, work colleague, why don't you come to my new place and work at this business that has far better package, better work-life balance and so forth. We permit these disgusting restrictions to be inputted into the legal employment contracts that most people will sign. And I don't know what the exact percentage is of employment contracts, but I know that in sales, a massive amount of sales contracts will have these, or sales staff, like, sales executives, BDMs, business development executives, commercial managers and so forth. They will have kind of across the whole, no matter what industry you're in, they will have these disgusting, appalling restrictions placed into them. Now, even if my contract said that I must disclose, and I've never signed a contract that said that, but even if the contract said I must disclose my new employer to my current employer, I still would never ever ever disclose that information. And secondly, I would never ever ever honour any restrictive covenant. Why? Because even though that would put you at risk of legal action, and it would do, even though the chances of them actually enforcing it are slim, it is possible that in some circumstances they would. Personally, I would never ever ever honour any restrictive covenant out of principle that the covenants are an absolute disgrace and they violate basic human rights. They do. They violate the human right which doesn't actually exist, but it should exist as a legal right. We need a new Bill of Rights for workers, but it should exist, and it goes against natural justice. It's an absolute disgrace that any of these, and they're also a restraint on trade, a totally illegitimate restraint on trade. They don't benefit anyone but bosses. So as a society as a whole, they don't benefit us, because workers are suppressed by these covenants, even though possibly in the vast majority of cases the businesses that write them into contracts would not enforce them in probably a vast majority of cases, at least in the United Kingdom, but they operate silently because the worker has signed a contract. In many cases they've not even signed them. In many cases, workers in Britain don't even get a physical written contract, even by email or on paper. They don't even get that in many cases. Yet the employer claims that you're under these covenants. But anyway, these covenants are an absolute disgrace. No employer should be permitted legally to have any control over any member of staff once they've left. That's it. They should have absolutely no control. If that staff member wants to work for a competitor to increase his remuneration, package, work-life balance, and so forth, he should be permitted to under every circumstance. He should be permitted to set up a competing company, to have he should be permitted to do whatever the hell he wants. If he wants to say to those members of staff, listen, come and work for us, you can come and work for this new company, you get more pay, you get better hours, you get better this, that and that, then he should be able to. Companies should have to compete. If we're going to have a capitalist system like we have now, which I'm completely opposed to as a communist, but we should have a system, if we are going to use this capitalism, which is a disaster and I'm totally opposed to, but in the short term, these, to improve the lives of workers, these covenants should be banned. And they should be banned, and it should be made illegal to write into the contract, not just banned and unenforceable. Companies should be fined hundreds of thousands of pounds for merely writing them into contracts. Because when you have people that are not as legally savvy, that are non-unionised, that don't know the law and don't know the circumstances, you could have a situation where, as it happens in Russia and India, as far as I'm aware, where restrictive covenants like non-competes are essentially unenforceable, so they're essentially banned. The courts do not enforce them, as far as I'm aware, generally. And in places like California. In places like California, Russia and India, you still sign a contract generally that has the restrictions in. So those workers that don't realise that they're not enforceable would potentially honour the illegal restriction, the unenforceable restriction. So it is important in my belief that not only are they banned, but that they are made completely illegal to write into the contract. It should be totally illegal to do that. Now in Britain right now, there was a consultation last year and the government are going to act on that consultation. They're going to either ban them outright, they're not going to ban all of them. Well, I don't know actually, but my feeling is they were going to either ban non-competes only, so that you can work for any competitor in the vast majority of circumstances, or they were going to make it so that the company, your previous employer, has to pay you money whilst you're fulfilling that covenant, that non-compete. So if the non-compete is 3 months or 6 months, the employer would have to pay you a percentage, as happens, I believe, in I think Germany or France or another European countries. In some European countries, the employer has to pay the worker some amount of money whilst they're forced to non-compete. Now, I believe again that it should be totally illegal, because I don't accept that that is legitimate and I don't accept that that is right. No company should be entitled to control of workers after they've left under any circumstances. That is fundamentally immoral and violates basic working rights of your right to work and carry out your trade. So that should be totally illegal. But it is better than what happens now, and it's better than what happens now because the vast majority of employers would never ever pay a penny for any restriction. They simply put these in the contracts because it doesn't cost them anything. They go on, I'm not kidding you, they go on Google and they type in employment contract off Google, and they just get a template up off one of them template websites, and they just copy and paste it off that, change the name and whack it in. And unfortunately the boilerplate, the lawyers who've made these boilerplate contracts are obviously aware that you're allowed to use restrictive covenants, and they've put them in. And ultimately, why I would never ever honour any restrictive covenant, well, first of all, so we're going to find out hopefully this year what they're going to do about it, whether they're going to ban them outright, and what they should also do, they should also ban exclusivity. Exclusivity meaning contracts will also say you as the employee can only have this job and you can't have any other income sources. Well, that should be totally illegal. No one should be able to exclusively control another employee. If the employee wants to set up another business, wants to do something completely unrelated to the company, they should be completely free to do so outside of their working hours. As long as they legally fulfill their contractual obligations to that company, they should be completely free to work for any company they want, other company they want, outside of the contractual hours for that company. But if you disclose the information, and I am aware of some contracts that say that, at least I've never signed one, but I am aware of some contracts that do say that you must disclose who your new employer is. But think about this. Employers will only very, very rarely enforce these covenants because they cost so much money to go to a court and instruct judges, instruct lawyers and barristers and so forth, and to get the judge's time in court and all that. Because it costs thousands of pounds to do that, the vast majority of employers, in my opinion, will not actually enforce their own restrictions. Some will, some with big deep pockets will, even though it's a total. And the second reason why they won't generally enforce them through a court, in a majority of cases, is because there is total uncertainty with whether the judge, whether the court would actually honour the restrictions, because the judges kind of have more leeway. They look at the whole picture of whether it would cause unfair hardship and whether really there's a you know, whether it's in the interest of everyone to actually enforce this contract and stop him from carrying out his trade, which is a principle, as far as I'm aware, of English law, that you have a right to carry out your trade. And so because of the uncertainty that a court would actually enforce the covenants even if you've signed them, and don't get me wrong, sometimes they definitely do enforce them. I've seen it where people have been restricted and it's a total disgrace. They can't work for 6 months for a competitor, which is utterly ridiculous, because how can someone carry out their trade if they can't work for a competitor? It's insane, and it's a total disgrace, which is why it should be made totally illegal, as I've already discussed. But if you disclose that information to your employer, they could, before you've left, you know, in your notice period, they could, within that time, within that 1 month, 2 month, 3 month notice period, they could potentially contact your new employer to say that no, he's under a restriction, he can't go there. They could potentially send you a pre-action letter saying, look, if you go, we're going to take legal action to a court, like we're going to get an injunction against you. Even if they have no intention of actually doing it, they could potentially threaten you. And so, in my opinion, you've been far better off never ever disclosing. Just say something like, oh, I'm pursuing new opportunities, or even lie and just say, I don't actually know where I'm going yet, I'm going to make my decision up shortly, but I'm going to take a few months off and then I'm going to start with a new employer somewhere else. Just say something like that. Now ultimately, I don't give two hoots about breaking any covenants like this, because there is no choice. Because if a worker wants to earn money, unfortunately, these covenants are in the vast majority of contracts, or they're in a majority of contracts. So it is unfair and ridiculous to say to someone, well, just don't sign the contract. If you didn't sign that contract, or if you scribbled a line out which had those restrictions, possibly sometimes it would be okay. Possibly. The employer would say, well, okay, I'll negotiate, I really do want you, I'm not bothered if you're going to go and do that, because the courts won't enforce them anyway, generally. Then, therefore, I'm going to let you scribble out that contract, and we'll just remove it from remove those covenants. Possibly, in some rare instances, that would happen, possibly. But in a majority of instances, the employer would say, you have to sign it, or you can't work here, including those covenants. So ultimately, it's a take it or leave it situation. Now, I don't believe that is fair. I believe those covenants, that you don't really have a choice. Just like I can't control O2's phone contract terms. I can't control those terms. Under this system, the terms are set by legislation that permits the possible scope of the covenants, which in this case permits restrictive covenants, which, as I've said, should be illegal and should be banned. And what the employer wants, what bosses want, what shareholders want. Now that's not democratic, and as a communist I believe in democracy, and I believe that we should control what's in those contracts, because we the workers generate the profit. We generate the profit. Never forget that. The second thing is, or the third thing is, so if you don't disclose that to your employer, if you've not confirmed or denied where you're moving to, generally they will still give you a reference. And the other thing is, once you've moved to the employer, I can't remember if I've actually said this already or not, but once you've moved to the new employer, it is far, far more difficult for them to do anything like getting an injunction or stopping you and forcing you to not work for that new employer once you've started carrying out productive work for that new employer. So you would be totally mad, even if your contract, in my opinion, tells you that you need to disclose. I would say the chances of them going to court are slim. If they do go to court, you can you should be a member of a union where you get access to your union's lawyers. You should do, which won't cost you a significant amount of money, because you should be paying your subs every month to your union. And ultimately, the court may not actually enforce the restrictions, or may not enforce the covenant that requires you to disclose to your new employer. Now maybe they would, but ultimately, in my opinion, it will, more times than not, disclosing where you're going to is generally very, very bad for the employee. Now, if you was going to a completely different industry that has not, and you had a good relationship with your manager or your boss, and I'm not saying that doesn't happen sometimes, then perhaps in that instance, who cares, just tell them. But I still probably would not tell them. I mean, don't give them any arsenal to stop you from working where you want to work. That is, in my opinion, the most fundamental thing. The most fundamental thing, the most fundamental principle is that workers' rights are upheld. That's what I believe. So I believe that workers, that's the main thing that I care about, that workers' rights are upheld. Now, by disclosing information, even if you've technically signed that you would disclose your new employer, that is still totally immoral, in my opinion. So it's not your fault that the system permits these disgusting contracts to exist, because those contracts are a disgrace to humanity and they should be ripped up. Now, hopefully, very soon, they will all be ripped up, hopefully. Hopefully the government, and I'm not betting on this, hopefully non-competes will be banned, and any other restriction would have to be paid for. So, now again, I would still never honour it, because they are such a grotesque violation of my human rights that I would never, ever honour it. But hopefully they'll be banned, and if they're not outright banned, including exclusivity, hopefully they will be basically made so that they will pay you money for the duration of the restriction, and hopefully they will statutorily restrict the restriction to say 3 months. Now, if that was the case, 3 months, you're getting paid to be, to be basically put on a garden leave, essentially. That's what it basically would be. It'd be an extended garden leave. So hopefully they will be banned outright though, or something like that happens, so the vast majority of contracts are ended, like restrictions are ended, but I'm not counting on it. But if it doesn't get banned, I would still honour my principles to communism and to workers' rights, and I would never ever stick to these disgusting covenants. And don't tell me that you can just not sign them. If you're an employee and not a boss or self-employed, a lot of the times you're basically forced to accept if you want to work. That's not a choice. That's not a choice. That's ridiculous. Oh, you can either put food on the table and pay your bills and sign a disgusting contract, or you can not do that. That's not a choice. That's ridiculous. These restrictions need to be banned. Never ever give in. Don't tell them where you're going. Stick up for workers' rights. Do what the right thing is. Make sure you're a member of a union. Cheers.